Y'all, I just did this whole lecture and it wasn't even recording, so I'm gonna do it again. Okay, let me share my screen. All right. I'm sure I did it perfect when it wasn't being recorded, but let's try it now that the recording is happening. Okay. Uh, all right. So welcome back. We are diving into one of the most important and sometimes most complicated topics in counseling ethics, and that is confidentiality. But to me, counseling, the whole point of counseling is confidentiality. I think this is one of the bedrocks of counseling is, this is the reason you're not going to your friend or your sister or your aunt or your neighbor or whatever, because they're not bound by confidentiality. You want to talk to someone who you know is not going to be telling your business and making your life more complicated, right? So confidentiality. So by the end of chapter 6, you should feel confident about what confidentiality really means, how it connects to privacy and privileged communication, and where the legal limits are, especially here in Mississippi. And I'll kind of refer to some of the Mississippi laws throughout. So let's get started. All right, so I've got 2 slides worth of learning objectives here. So we have a lot to cover today, but it's all connected. So by the end of this session, you should be able to differentiate between confidentiality, privacy, and privileged communication. Understand the purpose and limits of confidentiality. Limits is a key word, limits of confidentiality. Recognize issues that come up with technology like email and texting and stuff. Understand the basics of HIPAA and how it affects you as a counselor. And then we'll talk about your duty to warn and protect and what that looks like in practice. So if you've ever wondered, what exactly can I share and when am I legally required to share it, this chapter is going to answer that. All right, so we'll also touch on confidentiality issues related to dangerous clients, suicide risk, child abuse, elder abuse, and even HIV status. So there are all kinds of gray ethical zones where you can feel torn between protecting your client's privacy and keeping others safe. So remember how you handle these moments. It says a lot about your professional judgment and integrity. And so we're going to learn about that now. All right. So let's start by defining a few key terms: confidentiality, privileged communication, and privacy. So first, confidentiality is your ethical obligation as a counselor. It means that what clients share with you stays private. It's about trust. Clients need to feel safe opening up, and confidentiality is what allows that to happen. So confidentiality is your ethical obligation. Privileged communication is more of a legal term. It's the client's right to prevent you from disclosing information in court. So, but here's where it gets tricky. The specifics of privilege vary by state, of course. In Mississippi, privilege is recognized under a statute that protects communications between a licensed mental health professional and a client. However, there are some exceptions. So, like when there's suspected child abuse or when someone's safety is at risk. Um, and if a court subpoenas you, that gets complicated too with what questions they're going to ask. So, and then there's privacy, which is broader. That's a person's constitutional right to control their own personal information and to be left alone. So confidentiality is ethical privilege, is legal, and privacy is constitutional. All right, so digging into confidentiality, we're going to look at Fisher's 6-step model. So psychologist Celia Fisher developed a 6-step model for protecting client confidentiality. It's really practical. I recommend keeping it handy as you start seeing clients. It's pretty straightforward. So number one is preparation, meaning you need to know your agency policies and the relevant laws before you ever meet with the client. So that's what this class is for, kind of learning what your ethics and laws are. And then when you get onboarded in orientation for COPE, or at the schools, you're going to go through orientation where they cover all of the policies and procedures. And so pay attention to that. That's important. That's part of this preparation. Step 2 is telling clients the truth. Remember, veracity. So be transparent about what confidentiality means and what the limits are, especially around things like harm to self or others. Then step 3 is obtaining informed consent before making a disclosure. So that means your client fully understands what they're agreeing to share. It doesn't mean you're sharing everything. You get real specific on what you're sharing and you try to share the least amount as possible, So, for example, if it's for medication management, you might only need to share the diagnosis. If it's for, court ordered stuff, sometimes they only want to know that the client is coming. So you just show dates of attendance and you don't have to show anything else. So that's kind of what they're talking about there. What is the client really informing to be disclosed? And then step 4 is respond ethically to legal demands for disclosure. So, for example, if you get a subpoena or a court order. Now, if a judge court orders your files, you are legally required to release those. And before you release everything, though, you need to ask and be like, well, what do y'all really need? Is it just, like I mentioned earlier, is it documentation of attendance, or is it a diagnosis, or do you need all of the session notes, or things like that. And that's why you've got to be careful with your documentation, with your session notes. But a lawyer can also subpoena your notes, but you do not have to release those to the lawyer. This kind of goes back to getting the informed consent from the client. This would happen a lot when I was the clinic director for COPE. We would see a lot of kids, and lawyers would subpoena files. And so I would just call the parent and just say, hey, this lawyer so-and-so is wanting your child's files and information. Is this something that you know about? And most of the time, yeah, they do. They're like, yeah. I told them to give you a call. Please do release that because it's helping them with a custody battle or something like that. So you just call the client if you get something from a lawyer. If you get it from a judge, I mean, also talk to your client about that, but you can't get out of releasing it to a judge. You can tell a lawyer no. They'll try to bully you, but you can tell them no. All right, step 5, avoid preventable breaches. Be careful with records, technology, and casual conversations. A lot of it is preventable, right? So avoid preventable breaches. And then step 6, talk about confidentiality often. This is an ongoing conversation. It shouldn't just happen at intake. So revisit it anytime a new situation comes up. If you feel like we're moving into, okay, they're about to talk about suicidality, just remind them, like, okay, remember, we might have to, I might have to break confidentiality to help get you some extra support here if you do intend to harm yourself. A lot of times you'll have to do that with kids too. And that's not to tell them, shut up, don't tell me. That's just to remind them that, that you want them to be informed, consent informally, right? All right. So limits of confidentiality, kind of while we're on the subject. This is the yes, but side of the rule. So there are times you must share information, such as when clerical staff handles files. I know some of y'all are working behind the front desk at COPE. That's that. Because you're not their clinical provider, but you still kind of, have access to their information. Just their name is private information, protected health information, just the fact that they are a client. Also, that you're under supervision and have to consult, right? Especially as a practicum student or an intern, you've got to be really clear with clients who's going to know about them and in what capacity. So the way I frame it, and I tell students to frame it, is you're really getting like 2 or 3 even clinicians for free. If you're at COPE and even in the schools, you're getting PhD level attention to your care because we do videotape all these sessions and I do show them to my supervisor, and they're not looking at you, they're looking at me to make sure I'm providing the best possible care for you. So that's kind of how I frame that. And that is a limit of confidentiality because you are under supervision. And so you have to be clear with clients about that. A client gives written consent. So maybe they want you, they're saying, hey, can you talk to, my doctor about medication? Could you talk to them? Would you mind collaborating with them? And you get written consent for that. Or maybe it's a family member they want you to talk with. Maybe it's, like I've had an adult client who wanted me to talk to their parents and we got them in for a family session. So we got written consent for that. A client poses danger to self or others. Obviously we've got to reach out and get maybe sometimes law enforcement involved if it's a danger to others, or we even have to let the person who is the target know. And I'll talk more about that duty to warn here in a minute. um, or, danger to hurt yourself. And that, that might lead to inpatient if there's a clear intent and a plan. If there's a disclosure or of intent to commit a crime. Now, if they come in talking about a crime they already committed, but have, they don't have intent to do it anymore, you do not have to report that. So, you can keep the criminal's secrets. But if they talk about, or if it seems like there's a pattern and it seems like it's starting to look like there is some intent to commit crimes, then you do have to report that. You suspect child or vulnerable adult abuse. Of course, if someone else is getting hurt, then you've got to report that as well. I know some of you are mandated reporters, so you know all about that. And we as counselors are all mandated reporters once you start seeing clients. And then also when a court orders your records, which I've talked about just a minute ago. So in Mississippi, you're a mandated reporter as a counselor. And that means if you suspect abuse, you don't have to investigate it or prove it, you just suspect it. And then if you're reporting in good faith, that protects you from liability, even if the suspicion kind of turns out to not be uh, grounded in reality. But if, you suspect that there is some abuse going on, you have a duty to report that. All right. So telecommunication devices, this affects us all. Technology, right? We all have technology. We communicate with clients through email, phone calls, sometimes telehealth platforms, text reminders, stuff like that. Tools like Zoom and smartphones make life a lot easier, but they also raise major privacy concerns. So if you're using text or email, always make sure your client has given informed consent to communicate that way. So even if they say, yes, you can call me, you've got to even go further. Can I leave a voicemail? Because, that maybe they share a voicemail. Maybe their kid has access to the voicemail account and they don't want that information. Or can I send you a text? You've got to get clarification on that. All right. So HIPAA considers text and emails insecure means of communication unless they are encrypted. And so what I tell clients, they'll have my cell phone and I'll have theirs. We're only texting about scheduling issues. And maybe if I have a graphic about something we talked about, like a coping skill graphic, I might text that to them. But that's it. We're not having sessions over text or email. Please don't, talk about stuff that you wouldn't want everybody knowing because there could be a data breach, right? All right, so privacy issues. This leads us to privacy issues with telecommunication devices. So here's the golden rule. Never say anything electronically that you would not want read aloud in court. So just be mindful when you're sending emails, texts, leaving voicemails. You never know when you're being recorded. So just be really mindful. If you're talking to a client on your cell phone, assume someone else might overhear it. They might have you on speaker, whatever. Be careful when you leave a voicemail. I mentioned that earlier. You don't know if they're the ones that's going to check it. And if you're talking to a client, make sure it's your client that you're talking to. So in your practicum or internship sites, check the policies. They often require you to use secure email or agency approved systems. So anything when we're talking about clients like in private practice, we're sending messages through the Simple Practice platform because that's encrypted. So we're not texting each other. If the owner has a new client for me, she's going to send me a message on that encrypted message system on Simple Practice. She's not going to text me about it. All right. So also remember, once you hit send, you cannot control who reads it or screenshots it. So be really cautious and professional at all times. All right. I think I've touched on all this. I've just been talking. I haven't been clicking my slides. So, yeah. Yep. Okay. So now let's talk about HIPAA. The HIPAA is HIPAA, not HIPPA. It's not HIPPO. It's HIPAA, HIPAA. That stands for Health Insurance Portability and Accountability Act of 1996. So HIPAA was designed to make healthcare more efficient and to protect people's medical information, especially when it's transmitted electronically. So this kind of all came about electronic stuff online. So you think about mid late 90s, that's kind of when the internet was beginning to be a thing, and they were starting to do electronic medical records, and so that's kind of how HIPAA came to be about. So I have a lot of experience with this because when I was the COPE director, we were just kind of entering into a corrective action plan because for a HIPAA lawsuit. And what happened was at the University Medical Center in Jackson, a laptop with all kind of protected health information, PHI, um, it just disappeared. And I don't know that it was ever recovered. I don't know. I don't know the specifics. That's the gist of it. And that's why we had to go through this corrective action plan. And all covered entities, that's the term for it, had to join this committee. So I was on this committee, and we had to implement and show and document how we were protecting clients' health information. And so COPE was considered a covered entity. Um, and not because we didn't even have electronic medical records at the time. The reason we were considered a covered entity is because before it was COPE, it was called CAPTI, and it was Child Play Therapy Institute, and they billed insurance, and so that was electronic, and so that's the reason we were a covered entity. I don't think that the UCC was a covered entity at the time because they weren't billing insurance. So that was interesting to have to be one, and then UCC wasn't in there with us. But I think the director at the time, it wasn't Dr. McCormick, it was Bud, and he came to those meetings anyway, just because he wanted to know what was going on in case they did get roped in. So, and I think eventually they did. So that was multiple years along, that corrective action plan. That was going on the whole time I was the director of COPE, and that was for 4 years. That was super fun, y'all, she said sarcastically. All right, moving on. So the four standards of HIPAA, um, privacy requirements. So understanding what protected health information is, keeping our clients' information private. Just the fact that they are a client is a HIPAA privacy requirement. Then electronic transactions. So making sure that all of your stuff is encrypted, like where you keep your medical records, how you bill, how you submit claims to insurance, all of that is electronic transactions nowadays. And then security requirements. And so this is, how do you have your stuff on lockdown? What does the encryption look like? If you have any kind of physical stuff with clients' names on it or information, where are you keeping it locked up? Is it double locked? Um, what are the procedures for how employees or interns or whatever can access that, and how do you protect it, right? And then the national identifier requirements. This is the national provider identifier, an NPI. So every health provider is required to get an NPI. It's just a 10-digit number. I have one, and that's just so that I can submit claims and all that kind of stuff. Electronic data transmission is what that's for. So that's those are the four standards of HIPAA. And in Mississippi, HIPAA compliance is enforced, and it protects the confidentiality of mental health records. Now, for school counselors, it's not so much HIPAA as it is FERPA. And I'm not as familiar with FERPA. I am familiar with FERPA as a professor. But it's a little bit different because you all are adults. All of my students are adults. So FERPA is like the school equivalent, the educational equivalent of HIPAA. So it's all about protecting information and how you handle records and how you make changes and edits to records. And I'm sure our teachers in the class can tell us all about that. So the next thing we're going to talk about is duty to warn, and this is one of the toughest ethical areas, balancing confidentiality with protecting others from harm, people you may not have ever met, but they're people in your client's life. So um, you take reasonable precaution to identify clients who are likely to do physical harm to third parties, and then protect those third parties from the clients judged to be potentially dangerous, and then to also treat those clients who are dangerous. So if you have a client who is saying they are going to hurt someone on Thursday with a gun, you cannot let that client leave. It's just like with suicide assessment. If they've got a clear plan and means and all of that, you can't let them leave. And so um, there are procedures, and you'll get with your agency, and they'll kind of talk you through how to handle that. And we'll talk about that some more here too. So the duty to protect from dangerous acts of violence, clients entails liability for civil damages when practitioners neglect this duty by inadequate assessment of client dangerousness, failing to warn potential victims, failing to commit dangerous individuals, like letting them leave the office, right? You would not do that. Prematurely discharging dangerous clients from a hospital, things like that. So, um, if you're a psych major, you've probably heard of the Tarasoff case in California. It established the duty to warn and protect. A therapist failed to warn a young woman that a client had threatened her life, and she was later killed. So the court ruled that therapists have a duty to warn potential victims and take steps to protect them. So now here's the key. Mississippi doesn't really have a specific Tarasoff type statute. You're more bound to your ethical duty to warn. So the ACA Code of Ethics still expects you to protect identifiable victims from serious and imminent harm. So in Mississippi, this is generally handled under your ethical duty rather than a clear legal one, but many agencies have their own internal policies requiring you to act. So you just, wherever you're working, follow whatever their policies and procedures are. So if your client threatens someone, document carefully, consult with your supervisor, and take reasonable steps to protect that person's safety. So let's talk about these landmark court cases. I've already talked about Tarasoff. There's also Bradley versus Ray. It's a duty to not negligently release dangerous clients. Jablonski has a duty to commit dangerous individuals. Headland, I guess, talked about that Tarasoff extends to bystanders. So think, you're a receptionist in the office and you overhear it, but bystanders in general, and then not just mental health providers or school counselors or things like that. And then Jaffe versus Redmond recognized psychotherapist client privilege in federal court, and so communications between licensed psychotherapists and their clients are privileged and therefore protected from forced disclosure in cases arising under federal law. So anyway, these cases remind us that failing to assess risk or warn appropriately can lead to all kind of legal trouble and civil liability. So let's talk about dealing with dangerous clients. So risk management guidelines in dealing with duty to warn and protect situations. So you've got to first consult with colleagues or a supervisor, consult with an attorney if you're not clear about your legal duty. Know the relevant laws in your state and obtain prior medical and behavioral history. Inquire about a client's access to weapons, homicidal ideation, and intentions, and including whether a specific victim is involved. So, getting all this information is essentially called a harm, like a threat assessment, a risk assessment. I think it's risk assessment. Those of you that work in the schools probably know what I'm talking about. You've probably had to do it before or referred a student for it before, maybe. So, in cases of immediate threat by a client, do not hesitate to take steps to prevent harm to yourself. A lot of places have panic buttons. You can leave that room. You can break that confidentiality. But a lot of times it's not going to be a crisis. If they're there and they're in counseling and they're sharing it with you, they probably want help with it. So you make referrals where appropriate. That might be even for inpatient treatment. Consider all appropriate steps to take and their consequences. That would be your ethical decision making. And then know and follow through the policy of your institution. Document the people you consulted and the actions you took. Always document, document, document. The ones that you rejected, maybe you considered it and didn't do it, and then the rationale behind each of your decisions. But if you don't document it, it didn't happen. Just because you say it happened, you've got to have it written down somewhere. All right. So now let's look at duty to warn and school counselors. And let me find my place on my notes because I've just kind of been talking here. But school personnel have a duty to protect students from foreseeable harm. So it looks a little bit different with school counselors. Um, you're protecting life while maintaining trust with your students here. I really have just lost myself on these slides. Oh, here we are. Okay. So It looks a little different. School personnel in Mississippi have a duty to protect students from foreseeable harm. And so that means if a student reports that another student plans to hurt someone or themselves, you can't ignore it. So under Mississippi Department of Education policy, you must notify administration and when appropriate, parents or guardians, and that's almost always appropriate to notify guardians. So if a student is writing or if they're writing or a project or some art project, something like that, suggests violence, you have to treat it seriously and follow your school's threat assessment procedures. And so, like I said, you should know those in orientation. You should know your school's procedures, but you'll always have a supervisor there to help you with that. All right. So suicidal clients, kind of moving into this. They require a careful balance. This is where I was. I was looking at my wrong place in my notes. This is where you're protecting life while maintaining trust. So you're expected to conduct a reasonable risk assessment and document it clearly. So if you consult with a supervisor, note that too. If a client dies by suicide, courts generally look at whether you acted reasonably, not whether you could have prevented it. Sometimes you can't prevent it, but it's just did you assess it? Did you document it? Did you consult appropriately? Did you do a safety plan? Did you what kind of treatment were you providing? That kind of stuff. What kind of support did they have from you as a counselor? So, and remember, self-injury doesn't always mean suicidality. Many clients use self-injury to manage emotional pain, but still assess safety, discuss coping skills, and consider a safety plan. So let's talk about school counselor liability for student suicide. So school counselors are expected to be aware of the warning signs of suicidal behavior and need to have the skills necessary to assess a student's risk for suicide. And we will go over that in class and practice that. You also have a crisis class coming up where that will be touched on as well. So you will get those skills. So in cases where school counselors make an assessment that a student is at risk for suicide, it's imperative that the student's parents or guardians be notified. All right, so two cases are often cited here. Easel versus Board of Education. Counselors have a duty to use reasonable means to prevent suicide when they're aware of a student's intent. So you've got to loop the parents in, or you've got to use reasonable means. And then the next one is you've got to loop the parents in. Wake versus Polk County School Board. Schools can be held negligent for not notifying parents of a student's suicide attempts. So in Mississippi, the same principle applies under duty of care. If you know or suspect risk, inform the parents and guardians and document that contact. A simple what day, what time you called them, did they answer or not? Did you leave a voicemail? What did you say? If you did talk to them, what was discussed? You got to document even phone calls like that too. All right. So guidelines for assessing suicidal behavior, we'll kind of talk about this in general, just kind of run through some key suicide assessment tips. You're going to take direct verbal warnings seriously. Many people actually tell someone before they attempt, but don't be scared to talk about this with clients. You need to make a safe environment for them because if they feel like if they even breathe the word suicide that they're going to be committed to inpatient, they might not open up to you. So they need to have the safety to know that this is an okay subject to talk about. A lot of people think about this, but it doesn't mean they're going to do it. But if they are talking to you about it, you've got to assess for their intent and their plan and their means to be able to follow through. And so, one of the biggest red flags if someone's going to attempt is if they've already attempted, so previous attempts. And the higher the number of previous attempts, the higher the risk is. So that's a big red flag. Also, depression, hopelessness, impulsivity is a big one. And substance use because that lowers your inhibitions and increases impulsivity. So, if you're impulsive, you might be more apt to make a decision that you can't undo. So ask about plans, means, and access to weapons. If they have a plan and the means, risk is obviously higher. And then also assess the protective factors. The support system is going to be the biggest protective factor. If a person feels isolated, that's a huge risk factor. So, and I think I'm already, yes, so I'm on this slide. So if they express suicidal thoughts, gently explore whether they want to die or if they just want the pain to stop. Is this a passive feeling? Do they just not want to wake up in the morning and they're disappointed when they do wake up? Or are they really thinking about, I want to end it? Because most of the times they don't want to die, they just want the pain to stop. And we can work with that. We're counselors. All right. And the way we work with that, one of the first things, all right, I've talked about that too, is safety plans. So written safety plans are now standard. There aren't no suicide contracts, which research shows don't even work. The no harm contract or the no suicide contract. This was used when I was in 2008 and I went into agency work. And some agencies still might use a no harm contract or a no suicide contract. And if that's their policy, go ahead and do that, but go above and beyond that as well. You've got to do a safety plan. And a safety plan, a no suicide contract is just saying, I promise I won't hurt myself between now and the next session. And you put the date of the session and the client signs it and you client sign it and whatever. But that can also, another reason it's not good to only just do that, it looks like a CYA move, cover your ASS, a CYA move, right? So if a client does die by suicide and there is the family sues or you know somebody, the court, the board, whoever is looking into, did you take reasonable action? Not could you prevent it, but did you take reasonable action? One of those things is going to be a suicide or a safety plan. And so if you just do a no harm contract, it just looks like, well, you just did that just to say you did that and put it in their file and called it a day. But you've got to actually help the client, right? Do no harm, but also help the client. So a safety plan includes like coping skills, people they can contact, people that can help them, um, things that soothe them, what they need to do to pull themselves out of that headspace. And if they're unable to pull themselves out of that headspace, what do they need to do then? And that needs to be written down. And there are some apps that do safety planning. You can also just have it on a physical piece of paper and give the client a copy so that they can have that, because if they're not thinking straight, it's good to have something tangible to look at. So safety planning is very important. So is there anything else I want to say about that? We'll talk about that in class. All right. So, oh, the other thing too is if you're doing if you're beyond the point of safety planning, there's a law that says that you can seek involuntary commitment if there's an imminent risk and the client, you always want it to be voluntary, but if the client's refusing voluntary hospitalization, you can have them committed. But I've never had to do that. Most clients, if they're there and they're telling you they want help, and if it's inpatient, it's inpatient. Sometimes they take a little finesse and convincing of how it's going to be helpful and how it's going to be a good thing to get them stable. But 100%, I've always had clients willing to go if they need to go inpatient for that. So, all right, moving on to protecting children, elderly, and dependent adults from harm. Because this one, we're going to talk about mandated reporting one more time because this comes up constantly. So if a child, elder, or dependent adult tells you that they're being abused or neglected, you are legally required to report it in Mississippi, just if you suspect it. You don't have to investigate it or prove it. The law gives you immunity from liability if you report in good faith. Okay. So elder abuse can be physical, sexual, emotional, neglectful, even financial. I don't think a lot of people think about that, financial abuse or abandonment. And Mississippi defines a vulnerable adult as anyone over 18 who can't protect themselves due to physical or mental impairment. So even if you suspect mistreatment, you're required to report it to adult protective services. All right, so this one is especially sensitive. So legally, HIV status isn't confidential under Mississippi codes. You cannot disclose someone's HIV status to a third party without consent, even if they are engaging in risky sexual behavior. But if you believe a client's actions are putting others in danger, you still have a duty to warn. So you should always consult and, of course, document. Can't beat you over the head enough with consult and document. But consult with a supervisor, an attorney, the ethics board. But you generally cannot breach confidentiality solely based on an HIV status. So at the start of treatment, always explain your limits of confidentiality and talk openly about safe sex practices and the potential harm of non-disclosure. Okay. So, all right, that was a lot, but this chapter is one of the most important foundations of ethical counseling. So just remember that confidentiality builds trust. Privilege protects clients legally. Ethical judgment protects everyone, your client, the public, yourself. So in practice, you'll face moments where you have to make tough calls, but when in doubt, consult, document, and act in good faith. So I will see y'all in class. Thank you so much for listening.